court reached out and said, you may not meet the standards of Title IX, but you know what? We're still going to hold you accountable under 1983. You deprived this young woman of her civil rights.
And that goes to the differences between systemic liability for a district or an institution and which officials put the institution on notice and which officials take action. This is going to be a perfect lead-in a few minutes to our qualified immunity conversation, which brings in the good faith defense. And we'll talk about the fact that in many of these cases, the courts apply a sort of quasi-negligence standard. We talked about this before, where they asked, should the administrator have known or did he or she know that their actions would lead to a constitutional deprivation of rights? And that should they have known part of it, which is a constructive notice or constructive knowledge standard, opens wide up to say, well, you didn't know because you did it, but you should have known. And this is something you should have been aware of in the exercise of due diligence. And that is an area where we need to explore a little bit later on quite a bit more deeply, I think.
Absolutely.
Are we ready to move on to the McGrath discussion?
Yes.
Wonderful. Well, if we turn to slide 29, you will see the citation for the case Cynthia McGrath versus Dominican College of Blauvelt.